Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today we're talking about more people you didn't know you needed in your corner, the guardian ad litem.
Welcome to the show, everybody. I'm Seth Nelson, as always, with my good friend, Pete. And I got to tell you, Pete, I'm excited today because we have Courtney Bowes, a good friend of mine as well, a family law attorney here in the great state of Florida, more specifically in Tampa. But she is a mediator and a guardian ad litem. And I know, Pete, I know.
Yeah. Nobody knows what that means.
You've been up all night.
Yeah.
Like Google searching.
I gave up. We actually had the luxury of a meeting a few weeks ago doing a sound check. And I asked Courtney, I don't know if you remember, Courtney, I asked you the one question that had been plaguing me. I didn't know that Tampa legal professionals came from Hogwarts. What are you doing? Why does law make it so hard? Come on.
Courtney's like, I don't want to be on the show now.
Right. I take it back. Everything we've ever talked about, I take it back.
So what's a guardian ad litem, Courtney?
So a guardian ad litem is someone that's appointed by the court to make recommendations that are in the best interest of children in a particular case. So there are guardian ad litems that are appointed in dependency court when the state comes in and becomes involved in someone's family. And then there's private guardian ad litems, which is the work that I primarily do, where it's a family law issue, whether it's a divorce or a post-judgment case, and the court appoints a guardian in that respect.
So see, she's already like making it confusing. She tried to like make it where you could understand it.
Tried to make it easier.
Yeah, she's like, well,
we're back to potions with Professor Snape.
Where the court, okay, so Courtney, remember, We're dealing with Pete. He's not a lawyer. So whenever we say the court, Pete, we just mean the judge. But as lawyers, we have to treat the judges with a lot of respect. And so we don't even refer to them as judge. It's either your honor or the court.
Please the court. Please the court.
May it please the court. Well done, Pete. Winner, chicken dinner.
Welcome to season 2, everybody. I just got one right.
So, Courtney.
Yes.
When we're explaining this to Pete and to all our listeners out there, when would someone use a guardian ad litem? Because you're there on behalf of the children. You're not on behalf of the dad or the mom or one parent or the other parent.
Right.
You're the children's voice, so to speak. Is that right?
That's exactly right. I'm the children's voice. So a lot of times in most, let's call it a divorce case, right? In most divorces, we hear mom's voice a lot from mom and her attorney, and we hear dad's voice a lot from dad and his attorney, but you never really hear the kids' voices, right? You hear what mom and dad think the kids' voices are saying, but you don't actually hear the voices. So what the guardian is able to do is talk with the kids, talk with other family members, friends, professionals that have interacted and worked with the kids, and then report to the court what all these people say on behalf of the kids. So that's how the kids can get their voices heard in court.
And so just to make it even more complicated, Pete, is when Courtney's talking about, talking to school teachers or friends or other people, we call those collaterals.
Mm-hmm.
Those are other people. They're collaterals. So put that in your potion.
Do you even hear yourself sometimes?
I do.
Just making stuff up on the fly. Look, my question is this, and I don't know if you want to get into all of this now or if there's more detail to come later, but I'm sitting here as a position of a parent thinking, let's just say it's hard not to hear this without saying, okay, I'm relinquishing part of my voice as a parent to the guardian ad litem to then be the voice channeling my children in court. Does that make sense? Like, am I giving something up as a parent just because I'm in this process?
So I don't think that you're giving up your voice. What the guardian is able to do is bring information into court that otherwise wouldn't be admissible. Ooh, here's another word.
Another one, Pete.
Oh, okay.
Because of
definitely heard that one
that
before.
rule of hearsay, right? I bet that one's come up before. So because of the rule of hearsay, a lot of information cannot come into court during a hearing or a trial. So when a guardian is appointed, the vast majority of the time, the hearsay, the parents waive the hearsay rule.
All right, Pete, you ready for me to break that down for you?
Would you please break
I know
that
you're
down
like
for me?
you're like I need a drink already.
Allow me to serve as a vessel for everyone listening to this show right now. Please help me.
To answer your question about do you give up control, right? That's a great question. It's like most lawyers, the answer is it depends. So one part would be, well, if you don't want to have the judge hear what your kids are going to say, then you might be giving up some control, because now they're going to have a avenue through the guardian to talk on their behalf. Okay. Now, if you're the parent is like, hey, my kids are saying all this bad stuff about dad. Dad does this, dad does that. This is what dad says. This is how he treats us. So if you're the mom and you're sitting in court and your lawyer says, what did the children say about what happened at dad's? The lawyer is going to say objection, hearsay. Okay. Because what that is asking, and I'm going to say a very legal definition and then I'm going to explain it. Hearsay is an out-of-court statement. That's easy. That's something that the kid said out of the courtroom. All right.
Yeah, at home.
Right,
whatever.
wherever.
Right.
Offered in court, here comes the tricky part, to prove the truth of the matter asserted. So here it is. Dad says, my kids say that their dad hits them. Now, when you say that, you're trying to prove to the court that dad really hits them. Okay. You're not allowed to do that because that's what the kids said and you're hearing it and now you're saying it in court.
And when you say you're in this case, let's say mom,
I'm
say
the mom
you're defending,
in this case, right?
You're defending mom. Okay.
Right.
So she can't do that.
She cannot say, my kids say that dad hits them.
Okay.
And I want you, judge, to believe that dad hits them.
Yeah.
Okay. Because that's for the truth of the matter asserted. I'm going to distinguish that for a minute. And if they say, well, I'm saying that dad hits them, and then they say, oh, objection, hearsay, the lawyer on the other side thinks he's brilliant. And the other lawyer says, no, judge, I'm not offering it to prove that dad really hits them. I'm offering it to tell you why I think my children are afraid of dad. That's a whole different deal. Right. It's not necessarily true. I'm telling you, that's what they're saying. And I think they're afraid of him because they say these things. Not that it's true, but that's like a little workaround, so to speak. Okay. But when Courtney gets involved, she's allowed to go talk to the kids. And Courtney, as the guardian, the hearsay rule is suspended. And she can say, yeah, the kid said, judge, that dad hits them.
And that somehow, because it comes from you,
the guardian,
it is somehow vetted. Yeah, the guardian, it's somehow protected against the hearsay rule. And the judge will actually listen to you.
Right. Mom and dad have to waive the hearsay rule. So they stipulate that there is no hearsay for when I come in and testify. So I can say that the kids told me something, or the teacher told me something, or the children's therapist told me something. And none of those people are in court. I'm reporting it to the judge on their behalf.
Or it could be, Pete, I review the kids' report cards. And this is what their grades are. Because technically that is a statement of how the kids are doing in school, that report card.
Sure.
Courtney's not bringing that into court. She's just saying, I reviewed them, judge.
Mm-hmm.
Wait, so report cards, though, Courtney's the only one who can talk about those statements? Those are just like bank statements, right? I mean,
you can bring those in and you have all these exceptions to the hearsay rule, which we're not going to get into today, but that's a very good point. It's like bank statements. Now, here's the other key. There's a lot of times, like if you have an expert witness, an expert can rely on hearsay. So this isn't foreign concept when you're in a trial, but it is a foreign concept to parents when they're like, wait a minute, are you telling me anything my kid says to Courtney can say that in court? The answer is yes.
Mm-hmm.
Okay, I have another question. One, Courtney, this is a bit of an aside. Are the kids ever in court with you, or are you just representing them and you bring what they say? Is there ever a circumstance where the kids will come?
There are circumstances where the kids come, but the vast majority of the time, if I'm involved, the kids do not come. The only times that I've had cases where the kids have come in, the kids have been older, teenagers, and very specific circumstances. Otherwise, I go in on the children's behalf.
And Pete, just like we always say, and especially when we get into these details about hearsay or what a guardian ad litem does, or if the parent have to waive hearsay, that Courtney's talking about in Florida, mainly in Hillsborough County, where she does most of her work. So please, everyone out there, as I always say every show, and I'm sorry to repeat myself, check with your local attorney, make sure they're licensed in that jurisdiction, and check that jurisdiction on how they handle these types of issues. But these general concepts about what a guardian ad litem does should be fairly standard across the whole wide world here.
You should, for those listening, you should actually see if you can get one of Seth's business cards. It actually says Seth Nelson, Esquire, check your local jurisdiction. And that's it.
That's it.
That's all it
End
says.
of story.
Okay. My next question, and this is the thing that I've actually been noodling over since that really great Hogwarts quip I made a few minutes ago, is the hearsay rule as it pertains to other people, not the parents. Let's talk about doctors and therapists and other people. Like, is this all contained in your scope of work when advocating for the kids? It's a scope of work question, right? Like on a typical case, like how far do you get to go in representing sort of or protecting kids' voices?
It depends on the case and it depends on the issues. So I've had some cases with some very serious issues where I'm talking with the kids, pediatricians and specialists and therapists and talking with numerous professionals. I have other cases where I talk to mom and dad and the kids, and that's kind of it. So it really just depends on the issue that each particular family is having and how serious the accusations or allegations might be. And we take it on a case-by-case basis.
To put a little meat on that bone, Pete, we've all, unfortunately, in family law, might deal with something where one parent is saying the other parent is physically abusing the child.
Sure.
So then you're going to have to go review medical records, talk to the doctor, see what's happening there. It could be a parent doesn't do any of the homework. And let's say it's pretty easy to tell you have a week on, week off schedule. So the kid goes back 1 week with one parent, the other week, the other parent. And Courtney might go review all the homework and the school records and be like, oh, yeah, with dad constantly late on dad's mornings when he's supposed to be dropping off. The homework's not getting done. And the spelling test at the end of the week is a C or a D. But with mom, it's an A or a B, and the kid's always on time.
Mm-hmm.
So all that type of stuff. And where these issues arise, it's not like Courtney has a list and says, is there any domestic violence? Is there any this or that? It's parents are going to tell you, right? They've talked to their lawyer. They've decided they need a guardian ad litem. And then Courtney does an interview. Hey, what's going on? What are your concerns? What's the other parent doing that's going well? What do we need to work on? And that's where these issues come out.
Okay. At what point, you said something there that I feel like triggered a question I hadn't thought of. At what point do parents come to a decision that they need a guardian ad litem in between them and for their kids? That seems like it might be a hard decision to come to.
I think it depends on the case and the issues and different cases I'm brought in at different times. So some cases have really serious allegations right at the beginning of the case. Maybe it's one parent has a substance abuse issue, and the other parent is very concerned about the children's safety being with that parent, but they don't have proof to bring in front of the judge in order to prevail on getting some safety measures put into place, right? Maybe there's no DUI, there's no arrest, there's nothing but he said, she said. Other cases, maybe I'm brought in, once the parties have been in the process for a while, after a separation, maybe like what Seth's example was a few minutes ago, the homework's not getting done with one parent, or they're bringing the children to school late, or maybe the children are objecting to going to one parent's house after the parties separate, and they're having distress from a mental health perspective. So those are, maybe I'm brought in later on down the road. Sometimes
it could be anyone in the process who indicates, we need Courtney here, like one parent, the other parent.
Absolutely. The parent might raise it to the lawyer.
The court.
Yes.
Yep. Right.
Yep. Mm-hmm. Yep. Very good, Pete. That was impressive. The court, you said that.
Did you see what that did?
Yeah.
Look, just a minute ago, Courtney said maybe one of the kids objected to going over to Dad's house. And my instinct was to say, overruled. But I just want you to know I listen when you say things. I listen.
You're an
I may use
listener.
them incorrectly, but I listen.
But the interesting thing, and why I'm so thrilled to have Courtney on the toaster here, is because she's so amazing at what she does. And what I mean by that is not only is she very smart, but she can connect to kids very quickly within 1 or 2 visits, and where the kids will open up. Now, it's different if it's a teenage girl versus a 5-year-old little boy, right? But if you're talking to a 5-year-old little boy and let's say mom's concerned that dad's drinking all the time, the 5-year-old might not have the words to say, yeah, dad's cracking beers all night, right? But what Courtney might get out of that child in just talking to him is like, well, what's your bedtime routine? And then the kid might say, well, I take a tubby and, my dad gets it ready for me, but then I just do it on my own. And then I just put on my PJs and go to bed. Well, where's dad
where's dad?
Right. So,
I took him a 6-pack and then he went to sleep.
Or dad was already asleep,
Yeah, right. Okay.
So there's that. So to give an example of how Courtney does her job, I think helps people listening to say, okay, what actually happens? Like, how does a guardian do this? So,
and you have access to both parents. You're talking to everybody, and you have to somehow rationalize or sort of normalize those two positions against one another. Or is I use the word advocate for kids, and is that a word you would use, or is it just representing the kids, or how do you talk about it?
I don't look at it as representing the kids. I'm not their attorney ad litem. I'm the guardian ad litem. Right. So I'm not representing the kids, and I'm not necessarily advocating for the kids. I think that might be a misconception also. So I think the better way to describe it is I'm doing an investigation, and then I'm making recommendations to the parents and their attorneys, and then to the judge if it becomes necessary.
That recommendation is what Courtney thinks is best for these children.
Yes.
Okay.
But I'm not a decision maker in the case.
Just a representative of the facts and observations as you've collected them.
Right. I'm reporting.
Right. Okay.
I'm a reporter.
How much does the child's position, or let's say you've got somebody who's 13 and has a strong opinion on what they want to have happen next.
13-year-olds have strong opinions?
I don't know anything about that. Right. And so, like, how much of that strong opinion gets sort of filtered through you? Like, do they have a voice in this, or, how much do you take back to? I
think it depends on the circumstances, right? Again, it's a case by case basis.
Yeah, no, you guys are nonsense, both of you.
I know.
This case by case basis.
Depends.
So, certainly a 13-year-old.
It's like this is an elderly commercial for Depends. It's just nonstop. Maybe that'll be our first sponsor, Pete. Depends.
Yeah. Go for it.
Go ahead, Courtney. Sorry.
No, it's okay. I think a 13-year-old's opinion and feelings on things is probably going to weigh a little more heavily than maybe a 5-year-old's opinions on things. But it depends on what the circumstances are, right? If it's a safety issue versus if it's a, relocation issue, you're going to.
And by relocation, Pete, we mean if you're going to move from one, like, more than 50 miles, let's say, or if you're going to move from one parent wants to move up to Washington, D.C., and the other parent's like, no, we need the children to stay in Tampa. You can move, but I don't want the kids to go. That's a relocation, which those cases are very difficult because they don't settle. It's not like we're all going to settle and say, oh, we're going to move to North Carolina. Mm-hmm. Right. It's either one or the other.
Right.
But I think to Courtney's point about it depends is Courtney's evaluating kind of not just the age of the child, but their maturity, their reasoning for saying what they want. It's not, hey, I want to do this. I want to stay with mom. Well, why do you want to stay with mom? What's leading you to that conclusion? And that's the type of stuff that Courtney draws out of kids really well. And sometimes that child might say something that no one else is talking about. They might have their own point of view. And Courtney's like, I got it. I see what's happening here. And a cautionary tale, sometimes be careful what you wish for from a litigation perspective. If you have anyone saying, I want a guardian ad litem, I want a guardian ad litem, I want a guardian ad litem, because that parent wants them to talk bad about the other parent. And Courtney gets a relationship with that kid, and then all it comes out is, yeah, dad's drinking, but let me tell you, mom's bashing dad every time she gets. Mm-hmm. It's not like they're just opening up to Courtney about one parent.
Right. It's rarely a one-way street.
Yeah. Would they really be in this position in the first place? Like you gotta wonder, because I think the legal term for that is takes two to tango rule.
That is actually the 11th Amendment to the United States Constitution, Pete. That is well done.
I know, Seth. I know. Please. You think you need to take me to school on the 11th? Courtney, how do you do your job? Like it sounds like from what you're talking about, you see the worst in people through the eyes of their kids.
Yes.
How do you keep that straight in your head? Like, why would they bring you in if it was sunshine and roses?
I wish they brought me in on sunshine and roses.
Right? Like, if your only choice was, do you get the pony or not? Like, that's, you know.
I don't get those cases.
How do you do this? How did you end up here?
Well, I do it and keep doing it because these kids do need their voices heard, and the circumstances in which they find themselves through no fault of their own need a voice, and so my hope is that by the time I'm done being involved with the family, that they're in a better place than they were when I started. So that's how I keep going back and doing it, because hopefully they're in a better situation at the end and I'm making a change for the better. How did I get started? I had a judge call me up a couple years ago, probably 5-6 years ago, and asked me if I would take a guardian case pro bono. And you don't say no to a judge when they call you up and ask you to take a case pro bono.
But that's to Courtney's credit, to have a judge say, hey, I value your opinion. I've seen you in court. I've seen you in other legal organizations, and I really need some help trying to figure out what's going on in this case to protect these kids and do what's best for them. So that speaks volumes.
Thanks.
So, Courtney, as you know, the show really is about saving your relationships. So one thing that comes to mind that I think we should focus on, and we'd love to get your input, is you think you need a guardian ad litem. You know that person's going to talk to your children. Mm-hmm. You know, ultimately, though you're hoping they're going to just say bad things about the other parent, so to speak. Mm-hmm. But that puts that kid in a really tough position, right? They maybe they don't want to say bad things about either parent, or they want to please both parents. So that one time they'll say one thing, one time they'll say the other. How do you as a parent prepare your child and save that parent-child relationship to let them know that you can speak freely to the guardian? Because ultimately, if that parent's pressuring the child, like say bad stuff about dad, and they're planting that seed, I think that those parents are running a big risk. And since we are about saving your relationships, this just seems very dangerous.
Yeah.
On a breakdown of a parent-child relationship.
Absolutely. And after you do this for a long time, you definitely can pick up on cases where kids are being coached on what they should say, those pretty much scream out coaching, when it happens. So what I've been encouraging parents to say to their kids before I meet with their kids is that mom and dad, we both want you to talk with Courtney. We both think it's important for you to have a voice, and we both brought Courtney in for you to talk to and to have the voice, and encourage them to be truthful and to speak their truths to what's going on, and that no matter what they say, that mom and dad love you no matter what. I think that's the best way a parent can handle it. Not every parent necessarily says that, but that's what I encourage parents to say.
Seth, let's just say that you and Courtney are not working together, that it's some other guardian ad litem and maybe one that you don't want to deal with. And they come in and they bring this report that is unfavorable to your client.
Right.
What do you do in that case?
Settle.
That's settle the case, right? So that's a common thought process, is that when you have a guardian involved, whether you wanted it, the other side wanted it, and you objected and the court ordered it, or the court on its own said, we're getting a guardian involved, which the court has the power to do. Check your local jurisdiction. So always, Pete, always. So then it is a very common theme that judges will just do whatever the guardian says. And so when a report comes back and Courtney makes a recommendation that this is what the parenting plan should be, the visitation, the custody arrangement, or a child should play soccer or do this extracurricular, or this is how we should do things, it's very common for people then to settle their case within those parameters or pretty close. But let's say I have a client that says, no, I'm not settling. I think Courtney got it wrong. Or Courtney never's wrong, so we'll pick the other guardian, as you said. So what do I do as a lawyer? I will attack the assumptions. In every report, in everything we do, there's always assumptions. So a basic example, which this is not an assumption I would attack, but it's a great example to get the concept. I would ask Courtney, did you review the children's report cards? Yes. How were their grades on the week when, and let's say I represent dad, on the week that they were with dad? They were horrible. They were Fs. They were Ds. Homework wasn't turned in. Courtney, what, if any, assumption do you have in making that determination? She's making an assumption that that report card was an accurate report card.
Or that the assignments that were turned in that week were actually assignments that were done that week.
Exactly. There's all...
God, I could be a lawyer.
You're signing up, brother. Yeah. Let's go. Because I really need to be a podcast host, because that's going to turn out well. But there's always assumptions like that. And so when I go to, quote unquote, attack a report, here are the general areas of assumptions, or what Courtney does. And Courtney, if you disagree with any of this, let me know. Courtney gathers information so I can attack how she gathered it. Did she spend 10 minutes with this child, or did she spend an hour and a half? How many visits? Did she get a real flavor? Did she get a good picture? So how did she gather the information? Then she records the information somehow for her notes. So did she not write those notes from that meeting with that child until 3 weeks later? So maybe her notes are now flawed. Or did she do it right when she got in the car? Because you don't take notes when you're talking to a kid.
Well,
right?
Sometimes you do.
Oh, there you go. Courtney might.
Sometimes you do.
So she's doing it right away. So then you can attack the notes or her proper recording of those issues. Then she takes all of that and she does an analysis to come to a conclusion. So you can attack the analysis. And as a lawyer, you never really want to be in the position where the report, in quotes, goes against your client. I've gone to court, not just against a guardian before. It was actually a child custody evaluator, which is someone with a PhD that ran psychological testing on the parents and did everything Courtney does, but even with this added element. And I beat the report. So even though the doctor in that case recommended one parenting plan and my client wanted another one, at trial, the judge did not just go with what the doctor said. And the judge is not required just to do what Courtney said or the other guardian that we're talking about. They could have a bad day. They could get it wrong, or the judge just might see it differently. Because the guardian's job is to do all that investigation, collect the information, do the analysis, record it, do the analysis, and write the report. And that's their job. It's not to advocate. So when Courtney does that and she does a good job on that, it shouldn't really matter to Courtney, though we're human beings, what that judge rules, because Courtney's done her job. And if the judge hears from 30 other witnesses that maybe Courtney didn't talk to because they weren't asked to talk to, and they tell a different story, and the judge believes that and says, well, no one asked Courtney to talk to these 30 other people that just went in there and bashed mom. Mm-hmm. So Courtney only controls what she has control of. Courtney, do you disagree with any of that, or am I just brilliant today?
I think you're brilliant today, Seth.
Just today, though.
Just today.
For a very brief moment.
That's right. But today does come to an end. So that actually gets to another question that we were noodling over, which is like how heavily does the judge weigh the report of the guardian ad litem? Like it seems like something that is, that it sounds like you get a chance to attack or defend the report.
Yeah, you do. But Courtney, correct me if I'm wrong. Have you heard this in court from a judge? I'm not prejudging the case, but I can tell you in my 5 years in family law, I've only not agreed with the guardian 3 times. Like
I've heard that. Yeah. I have had a judge not agree with my recommendation. It happened once.
Once.
Yeah.
See how she's a little annoyed by it to this day?
I am.
Could you hear that?
You could kind of tell, like, man, I was
surprised.
She gave us the real side eye for even asking the question. Sorry to bring that up, Courtney.
No, it's okay. I was brought in on one issue. It was a single issue, and I recommended one way, and the judge ordered a different way. There were 2 options, A or B.
Interesting.
So, but otherwise, I think a lot of times judges will take the recommendation and maybe tweak pieces of it. So they'll maybe adopt big chunks, but then pieces they'll tweak.
There's no real winning in family law.
No.
So
everybody in some way loses a little bit.
Everyone loses
a little bit or a lot.
Yeah.
So is there a circumstance, maybe this is more for Seth, is there a circumstance in which you as an attorney would tell your client, you need to change your behavior so that we can avoid bringing in a guardian ad litem? They're going to uncover things that may be unfavorable, that maybe, we just need to avoid that process.
Absolutely. I'll give you a perfect example, which has been very successful. And I think a lot of good lawyers use this. I'm sure Courtney does when she is representing clients. A frequent reason to have a guardian is when you have a parent who's suffering from alcoholism and their substance abuse. What I frequently recommend, and this might sound counterintuitive at first, Pete, is to tell that client, do you believe you're an alcoholic? Now, it's all attorney-client privilege. I'm talking to them. If I get an answer that I think is, I believe they're an alcoholic by the way they answer the question, okay, and I've been doing this a long time, I'll tell the client, here's what I think we should do. It's up to you. I give advice and counsel. It's your decision to take it or not. I think they're going to get a guardian ad litem, and that guardian ad litem is going to look into this issue. And that guardian ad litem is there for the kids, and it's on their behalf. And so they're kind of looking to protect your children because that's their job. So tie does not go to you. It goes to the kids.
Yeah. They're in that case, they're protecting the kids from you.
Right. So I recommend that you start voluntarily getting random alcohol tests. And I want you to continue that on a weekly basis or whatever the random drug tester recommends. And then by the time we get to court, if you've passed them all for the last 3 months or 6 months, then we go in and you say, well, sir, did you get an alcohol test? Yes. Why? I knew this was going to be an issue that my wife was going to raise. Okay. And I wanted to though I'm not an alcoholic, I appreciate that she's concerned about that. And therefore, I wanted to get tests to help alleviate her concerns. And by the way, here's 6 months of random alcohol tests. And Judge, I don't think we need a guardian ad litem. Here's 6 months of tests.
Mm-hmm. Mm-hmm.
And now the guardian doesn't get in there on alcohol and find some other stuff. Because no one talked about the cocaine.
Isn't that the truth?
Oh my goodness.
Yeah.
Here I am thinking after 6 months, I'm going to be clean and sober, but I eat about 70 Butterfingers a day. And you guys go straight to the Coke.
It's always the Coke.
It's always the Coke. And now we know what's on Courtney's business card. Courtney Bowes, quote, "It's always the Coke."
But that's a reason to, so sometimes you don't want people, like you say, noodling around in there.
Yeah. This has been incredibly illuminating. Courtney, if there's one part of your job that you feel like we have not litigated on this podcast for you, what would you like to leave people with in terms of understanding what you do as a guardian ad litem?
Well, I think we've covered a lot of it for sure. I think it's important just for people to remember that the guardian isn't being brought in to take sides with either parent or to be an advocate for either parent. The guardian's there for the kids. And, at the end of the day, that's what the appointment's about. And also keep in mind that if you do have a guardian and they are preparing a report, even if the report is making recommendations in favor of one parent, that parent's not going to like what the report says because the guardian has to dig into everything and nobody's perfect. We're all human. So typically the reports are going to be unflattering for both parents. It's just the way that the recommendations may fall. So when a guardian reaches out prior to preparing the report to make some informal recommendations or suggestions to the attorneys for settlement purposes, they should really consider it before the report gets drafted.
Before the hammer falls.
Yeah.
Well,
Wow.
Pete, do you really want to read what a third party thinks about your parenting?
Mm-mm.
No, I do not.
And do you want to pay that person to do it?
Oh, God.
Right.
Oh, we didn't even talk about that. So who does pay for you?
The parents.
The parents pay for you.
Yeah.
And sometimes the lawyers will argue over what percentage one parent should pay versus the other based upon a host of factors, how much money they have, incomes, or what we think the problem is. And And
it's been incredibly illuminating.
It can sound like lawyers might not want this because it makes everything more complicated but I'll tell you, a lot of lawyers will be like, let's get a guardian.
Mm-hmm.
I can't go depose or interview your child. If you're telling me these issues are, the only way for me to uncover those and bring them before the court is a guardian. I can file a motion to have a judge talk to a child, but that's going to be...
Are the judges really the most equipped party to interview a child?
I'll answer it, Courtney. I can see the look on your face.
I'm like watching Courtney not wanting to answer that question. Wow. I did not know that was going to be a conversation grenade.
Question. So here's the deal. It's very difficult for a judge who is skilled at asking questions and skilled at connecting with people to interview children because they're coming to a courtroom or into the judge's office. They're always going to have a deputy or a bailiff there with them so the judge can't be accused of anything wrong happening. Mm-hmm. It may or may not be recorded by a court reporter. It's just a bad place for a child to be. And now you're asking this judge who's doing the best they can on behalf of justice and trying to figure out what's happening to make the best decision for this child, having to get answers in that scenario. I mean, it's a lot better when Courtney can go to their home or go see them at a swim practice or in their own environment. It is a foreign environment to our clients, to the parents. Mm-hmm. Now take a 13-year-old having to walk in like going through airport security, but it's a courthouse and they're going through security. and then they come up and they're trying to dress nicely, and maybe they're not really used to having to wear a collared shirt, but they are because they're going to go see it's just not a great place.
Everything's terrible in that situation.
Right. And the judges doing the best they can. Now, there's some judges not talking to kids because they don't think, probably rightfully so, anything they're going to get out of that kid is worth putting the kid through that.
Right.
Mm-hmm.
So, see, Courtney, I covered for you there.
Thanks.
That was great.
That was good stuff.
Yeah. You're a good team. All right, you guys. Hey, this has been fantastic. Thank you. Super illuminating, Courtney. Thank you so much for teaching us a little bit about what you do and how you do it and why you do it. I hope this is useful for everybody out there listening. And make sure, as we're cruising through our season 2 of How to Split a Toaster, if your podcast app has a directory that allows you to leave reviews, we sure would love you to jump in there and leave us that 5-star review and nice comments. Frankly, if it's not 5 stars or a nice comment, we're less interested.
You can email me. I would like to hear those because I'm always trying to improve.
We'll hear those. Right. Thank you all very much. On behalf of Courtney Bowes and Seth Nelson, I'm Pete Wright. We'll catch you next week right here on How to Split a Toaster, a divorce podcast about saving your relationships.
Seth Nelson is an attorney with Nelson Coster Family Law and Mediation, with offices in Tampa, Florida. While we may be discussing family law topics, How to Split a Toaster is not intended to, nor is it providing legal advice. Every situation is different. If you have specific questions regarding your situation, please seek your own legal counsel with an attorney licensed to practice law in your jurisdiction. Pete Wright is not an attorney or employee of Nelson Coster. Seth Nelson is licensed to practice law in Florida.